Good morning. My name is Helen Bernstein. I'm Counsel Program Development at the Law Society. We want to welcome you all to this morning's program, What Law Clerks Need to Know About the New Expanded Application of the Family Law Rules. The program's being seen live in Toronto and also along our interactive learning network at a number of locations across the province. If you are attending at an interactive learning network site, we ask you to please help us by checking your name off the attendance list. We encourage everyone to complete the yellow course evaluation form that's in your binders since they help with future programming. And we want to mention that the program today is being videotaped. As for questions, these will be addressed at the 10:30 question and answer period near the end of the program. We'll take questions from Toronto first and ask you to put your questions on the white question sheets that you've been given and submit them to a staff member if it's during the question period, or if it's in advance of that question period, you can put them in the boxes at the front. If you're watching on the Learning Network and have a question, please hit *22 on your remote or keypad. The operator will then know to connect your site to the program, and sites with questions will be called upon in order, and your question will be directed to the appropriate presenter. Finally, we want to thank our chair, Risa Sheriff, Senior Counsel with the Civil Family Policy and Programs Branch of the Court Services Division, Ministry of the Attorney General, as well as all the members of our faculty for all their help in making the program come together. I know you're in for a very interesting morning, and I'm pleased to turn the podium to Risa.
Good morning, everybody. I can't think of a better way to spend a Friday morning than talking about the rules. And I'm thrilled to know that there's people out in the virtual world listening to us too. So I thought I'd just introduce our panel very quickly now because we have a precious 2 hours, and that way we can spend the whole time talking about the rules. So I'll do a few introductory remarks, and then Laurie Pawlitza, who is a lawyer in Toronto practicing exclusively in the area of family law and who sits on the Family Rules Committee, will talk about the continuing record. After that, my colleague, Linda Carello, who is a consulting manager in Court Services Division, which means she knows everything about what goes on in the field, will do a continuing record workshop, so we'll get a really practical idea of how the record works. Then George Karocidis, who's also a family lawyer in Toronto, will talk about case management, and I'll finish up with some odds and ends and talk a little bit about resources in the court. And everybody's bio is in the material if you want to know a little bit more about us. So just to start off, I was curious to know, and I can only do this in Toronto, but how many of the people here are completely new to the rules so that you have not dealt with them because you don't have an Ontario court practice? So nobody's raising their hands in this jurisdiction, so everybody's already dealt with the rules in the context of either an Ontario Court of Justice or a Unified Family Court. Well, that's interesting to know. So for you, you've got some familiarity with them, but there have been some changes, and we'll go over that today. And for the people out in virtual world, if you have not had an opportunity to work with the rules, we're really going to emphasize and talk about the rules as though you've never dealt with them before, regardless. So I did want to indicate that even though the rules have been in place since 1999, since the fall of 1999, in the Ontario Court of Justice and what we commonly call the Unified Family Court, and they were intended to be a wholesale change in the way family law cases are conducted in Ontario. And now, effective July 1st, they will apply to the Superior Court of Justice. And what that means is there are no more rules of civil procedure for family law cases in the Superior Court of Justice. Now, just some highlights of the rules. They are specially designed for family law cases, and that means that there's a recognition now that family law cases are different from civil cases. They contain a statement of intent and principle called the Prime Directive. That's in Rule 2, and I would encourage people to look at it. And basically it says that the primary objective of the rules is to enable the court to deal with cases justly through case management, which means early intervention into the case, timetables to help move the case along, and an emphasis on efforts to settle the case, or the issues in the case if the whole case can't be settled. We have the same rules and forms now for all family courts. That's a good thing because we are trying to move toward a consistent practice across the province. So, as I said, it means that we don't have rules of civil procedure anymore, but it does not mean that the Superior Court of Justice has become a unified family court. In other words, the Superior Court of Justice retains the jurisdiction that it has to hear certain types of family law cases. So now it does not now, as a result of the expansion of the rules, have the jurisdiction to deal with adoption or child protection. It deals with the cases it dealt with before July 1st, 2004, but it just deals with them under the family law rules. Another feature of the rules is plainer language. Some of you maybe by now know some of the new jargon. We don't talk about an ex parte order. It's an order without notice. We don't talk about variation applications. We talk about motions to change. We don't talk about pretrial conferences. We talk about case conferences, settlement conferences, trial management conferences. Matters are not done on an interim basis. They're done on a temporary basis. And we don't talk about discoveries and cross-examinations. We talk about questionings. So we're going to get the word police out there. I still find myself slipping back into the old terminology, but every now and then somebody slaps me into shape. Simplified forms. I suppose the jury may not be out on that one, but I think everybody has a reaction to the forms. But they are, you will notice, they have prompters and tick boxes. There was a huge impetus in developing the rules to service the unrepresented litigant. And I think there's a recognition that there are more unrepresented litigants in the system. And in addition, that it's important for people, even if they are represented, to have a better understanding for how the forms work and to understand what procedure means. And so it's important that these forms and rules be accessible from the point of language. There is one originating document. It's the application. There are several iterations of the application, different types of application, but there's one originating concept. And in addition, we have certain case management and settlement features built right into the rules, and George will talk more about that during his presentation. But basically, we have the conferences to narrow the issues and encourage settlement and impose timelines on the case. Of course, we have the infamous continuing record, which Laurie Pawlitza will talk about. And it's basically the way the court file is organized in the case. The other concept about the rules is accountability. There's upfront disclosure. There are certain requirements in terms of attachments to the financial statement that are required to encourage disclosure at an early stage in the case. And of course, the notion of costs, instead of waiting till the end of the case to determine what the cost should be, Rule 24 indicates that costs are supposed to be determined at each step of the case. So this notion of having assessments to deal with costs hopefully is not going to happen at all. And then there's some sort of structural changes to the rules. The first step, and this will be talked about more in the case management component, but the first step is generally a case conference. We want to get away from the concept of motions and fighting and ugly affidavits, so we try to contain ourselves and be civil and have a case conference instead. We don't have questioning as of right, so again, de-emphasizing this adversarial approach to litigation. It's as of right in a child protection case, but not as of right in any other case, meaning you have to ask the court for an order to have a questioning. And I think that's basically the highlights of the rules. So I'm hoping everybody has their binder. We've got some articles in there, and you should have some materials for the continuing record workshop. And off we go. Thanks.
As Risa said, I'm Laurie Pawlitza, and I note the tentative applause, and I hope that that's not a reflection on our topics, but we're in for the expanded family law rules at this point, like it or not. It's after July 1st, so here we are. I'm actually very impressed that so many of you have come out on an August morning in the dog days of summer. I assume it's probably fear that's driving it and the weather, as opposed to a burning desire to learn about the topic, because I myself will confess that rules have never been my favorite topic, notwithstanding I'm on the Rules Committee. So in any event, I'm going to just begin with a little anecdote, because I think it sums up why we've made efforts to change the continuing record. In mid-June of this year, I was standing in a courtroom in an unnamed jurisdiction, adding materials to a 9-volume continuing record and numbering about 200 pages because the respondent hadn't numbered the pages. Aside from being time-consuming, it was made somewhat more stressful by the fact that the respondent was acting in person and was there hovering over me because he had materials to add into the record, and I was trying to put the respondent in jail. So at that moment, I had very much wished that it was the 1st of July and the new continuing record rules were in place, because there are such significant changes to the rule, which obviously I think are going to make our lives a lot easier. Now, just to begin, the first thing that you all are going to have at the ready when you're dealing with continuing records are really 4 things, okay? Obviously, you're going to need a copy of the new rules, and you're going to want to have that at your elbow. And in particular, when you're doing a continuing record, there are 3 new rules that you really need to pay attention to. Rule 9, which is the continuing record rule, has been significantly revamped. So you'll want to have that right there at the ready. You'll also want to take a look at Rule 13, sub 7, which deals with tax returns and what you need to attach to a financial statement, because that rule has changed and we've made your life a little bit easier as far as that goes. And Rule 17, sub 21, which talks about case conference briefs, settlement conference briefs, and so on, not being part of the continuing record. Now, I said 4 things. The other thing that you are going to have, and you will come to know, and it will be very near and dear to your heart, are what we are calling the formal requirements. So if you look at Rule 9, sub 6, it basically says more details are found in the formal requirements. The formal requirements are on the website, gives the website address and the rules, but just so that you know, it's www.ontariocourts.on.ca. So those are the things that you are going to want to have at the ready, and they're going to tell you everything that you need to know about putting together the continuing record, what's in, what's out, and so on. What's best, just by the way, about the formal requirements is a chart that's in the back. So I frankly think that that's the best invention. And the chart says very clearly what happens, what goes in a continuing record if you're just doing one continuing record, which I'm going to talk about in a bit, or what happens if you're doing an applicant's and respondent's record, what goes into what goes in and where. So that's your cheat sheet, that's your guide. Use it and use it well. Although pretty much everybody here has dealt with the continuing record under the old Rule 9, I'm just going to say a word about the continuing record under the old rule. And under the old rule, as you'll recall, the person starting the case would start the record. It would have a red cover, a cumulative table of contents, an endorsement section, and then a section called documents that would have everything else in the case, whether it was the applicant's documents or the respondent's documents or the children's lawyer's documents and so on. And it would just be numbered chronologically, no tabs, and if the record got big, well, perhaps I was the only one that had organizational issues, but I can tell you that my assistant told me if there was one thing I would do on the Family Rules Committee, it would be to change the continuing record rule. So we're here, and that's why we've done it. The reasons, obviously, that there were problems were, I think, largely if the case got big, it was really difficult to coordinate the various records, the page numbers in the court's record, the applicant's record, respondent's record. We were always supposed to exchange tables of contents. Perhaps it was just me, but I never seemed to get anybody else's tables of contents, and so we never knew what page was what. It was always an adventure when we went to court, because page 454 never meant the same document in anyone's record as far as I could discern. Now, the rule has been significantly revamped. And first of all, let me tell you what doesn't need a continuing record, because that's always good to know. Look at Rule 9 sub 2. What doesn't need a continuing record is basically the things that you would expect are too small or too simple to make everybody put together a record. Like a joint application for divorce, an uncontested divorce. If you're moving and it's after July 1st and you're doing a notice of change or a motion to be removed, the lawyer doesn't have to do a continuing record, even though that might be the first step in the action, if he's just trying to get off the record. So that's good news. And the other thing that does not require a continuing record is a consent for a final order. So those are all sort of small things that you should expect, and to my mind makes sense, that a continuing record is not required. What does require a continuing record? Well, the short answer is everything else. Everything else that's not in 9 sub 2. So we have different types of family law disputes that find their ways into the court. And so all of those family law disputes are going to have what we would call a distinct record. And we do that anyway, just as a matter of course under the rules of civil procedure. We used to do different types of applications. We've formalized that under the rules. So just so that you know, there's going to be a record, obviously, for what I would call the garden variety family law dispute, where property, custody, support are all an issue. There's going to be a distinct record for support enforcement. That's Rule 9 sub 3. There are distinct records for child protection. So child protection and a status review are going to have separate, distinct types of records. And for that, you look at Rule 9 sub 4 and 9 sub 5. The children's lawyer, if they want to do so, can do their own record. You can find that at 9 sub 14. And that rule that we've got to change a final order, a motion to change a final order, that's Rule 15. Rule 9 sub 18 says you can do a separate record for that. You must do a separate record, a distinct record, we call it. Okay? So just know that there are obviously different kinds of family law applications, and they're going to say they're going to have distinct records. That's no mystery, but just be aware of it. Who is responsible for doing filing and maintaining the record? Well, the persons whose documents are being filed. So look at Rule 9 sub 11. If it's your documents, you're responsible. That's no change, but just be aware, because sometimes we have difficulty keeping track of documents, and remember that it's always your responsibility. Now, I'm going to get into the places where we've really revamped the rule. And the first one may seem like a small little change, but Justice Zutrin in Hamilton, at least, is very pleased that we've made this change. And that is the tab amendment. So just so that you know, we're no longer organizing the record without tabs, with just consecutive pages numbered for the whole record. It's going to be organized by tab. Each document in your continuing record is going to have a tab, and behind each tab is going to be separately numbered pages, just the same way as you would do it in a Superior Court record. So, for example, notice of motion might be at tab 1, and your notice of motion might be 3 pages. So it'll be pages 1 through 3. The next one might be tab 2, and you'll be in a situation where your affidavit's at tab 2, and your affidavit, as it's spit out of the computer, always has numbered pages. So they're numbered 1 through 15. So every tab is going to have its own numbered pages, but you don't have to have chronologically numbered pages throughout your record anymore. But remember, you need tabs. When you get to the point where you're doing your table of contents, we actually don't need a tab for the table of contents, just so that you know. The tabs rule, by the way, is in the formal requirements. So when you pull your formal requirements off the off the web if you don't happen to have a copy at the office already. It should print out at pages 3 and 4, and you'll find the tabs rule there. Okay? Now, there are some exceptions to the way that a continuing record is started, but let me begin by saying every continuing record is going to have 2 parts, and that's the most critical part of it. 2 parts means basically 2 volumes. And so part 1 of the continuing record is always going to have the same thing in it. That is the table of contents, a space for endorsements, pleadings, and financial statements. Okay, so that's always going to be in part 1, or what's the first volume. The second part, which is going to be in a separate volume, will have everything else. So affidavits, reports, so on and so forth. A couple of exceptions to that. One is a status review continuing record, and a support enforcement records will not be 2-part records, nor will the children's lawyer record have 2 parts. But those are the exceptions to the rule, and you will find all of this information, just again, in the formal requirements at page 4. The biggest change to the continuing record rule, and the one that I'm frankly most jazzed about, is found at Rule 9 sub 7. It's only available in standard track cases, but it allows the applicant and the respondent to each have their own record. So you don't have to coordinate with the other side in trying to put together one record and exchange documents and exchange and update tables of contents where you're both filing documents. So you have an option to do one record. So you've got a part 1 with the, what I would call the pleadings, financial statements, and so on in it, and part 2 with both of your documents in it. Or if you're the applicant or the respondent, you can file what's called a separate record when you're starting a case. And there are provisions in the rule to do separate records if you're into a case already. Now, if you're going to have a separate record, the applicant's record is going to have a table of contents in part 1, the endorsements. So the applicant's record is always going to have a space for the endorsements. It's going to have their pleadings and their financial statements. That's what's going to go in the applicant's record. And part 2 of their record is going to have all of the rest of the applicant's documents. Notice of motion, affidavit, reports, whatever's going to go in there. When the respondent files his or her record, it's going to have a table of contents, no endorsement section, because that's always going to be found in the applicant's record. It's going to have their pleadings and their financial statements. And then their part 2 is going to have the rest of the respondent's documents. So the beauty of that is you don't have to worry. You have to give your table of contents to the other side when you're serving your documents that are the subject of what's coming next in the case. But you don't have to worry about coordinating page numbers and filing with the other side, because their documents are in their record, your documents are in your record. The only change really from a superior court matter is that you're in a situation where you're going to have all of your documents in a continuing record, and they'll have all of their documents in a continuing record. So even if you start a case or you're in the middle of a case and you don't have separate records, you can ask the court by filing a 14B motion just to do separate records. And that's an over-the-counter motion. And then when you begin the next step in the case, then you can start with the separate records from the place that you're starting. So the next step in the case, your record is going to start with the current, for example, notice of motion and affidavit. And you must also do a part 1 to your record when you're starting a separate continuing record. So if you're in a situation where you don't have continuing records now, that's what you need to do. If you want to do separate records, or if you're in a place where you do have continuing records, you can separate the records. So look at the formal requirements, look at the rule. I'm just going to have a word about what's not in the continuing record because there are a few changes in that regard. So the things that aren't in continuing records now are going to be affidavits of service. You don't have to file those in the record. They are going to go in a sleeve in the court file, one of those little folder things in the court file. So that's where they're going to be found. Confirmation forms don't go in your continuing record. And be aware, this is a change, case conference briefs do not go in the continuing record. They are now going to be separately found, separately filed. So look at Rule 17 sub 21 and 17 sub 22 where we talk about the case conference briefs and settlement conference briefs. Those are going to be separate records. The rationale is they often contain settlement information. They come back to the parties. They don't stay in the court file. That's the intention. So look at those rules. That's a significant change. One other thing, just while I think of it, Rule 9 sub 13 is very clear, and it basically says that if you have something already that's in the continuing record, for heaven's sake, don't put it in again. Make reference to where it is. That's the whole idea behind a continuing record, so you're not reproducing and reproducing and reproducing the same stuff. Okay. Similarly, just in terms of the financial statements, you'll all recall that we used to have to file under Rule 13 3 years of tax returns with the financial statement. Often very big, very bulky, and really not as necessary as we originally thought. So now, look at the amendment to Rule 13 sub 7. You just need to file the 3 years notices of assessment attached to your financial statement, so that's going to make things a lot thinner. Or alternatively, if you don't have the notices of assessment, file the direction to CCRA. That's all you need. A court can order that you file the returns, but you're not required to in order to get your financial statement filed. So just know that that's the case. Now, I'm just going to talk a little bit about colors because this is really what proves the Family Law Rules Committee is a really fun bunch. We have fun there. We laugh. And let me tell you why. We were trying to decide what color we should make records because, you know, we talk about important things there. And we liked red because we thought, well, if somebody's starting litigation, they're probably seeing red. So we thought that makes sense. We're going to hang on to red. So if there is one continuing record and you've only got one, it's going to be red. But if you're separating records, we thought, well, how's somebody going to feel if litigation is commenced against them? They're going to be depressed. So we said, well, we should make the respondent's record blue. So we did. So remember that. That's easy. Respondent's record is always going to be blue if you've got separate records. Applicant's record is always going to be red. If it is one continuing record and you stick with that because it's not a very document-heavy case, it's always going to be red. Now, we also thought, well, support enforcement, we should probably do something different with that just so it's easily identifiable in the file. We thought, well, they're always looking for money, support enforcement, that's really what it's all about. So it's green. Okay, that's the best we could do. We don't have a lot of fun at the Family Law Rules Committee. So those are easy things to remember, but be clear. I've already gotten respondents' records that are red and they've been rejected at the court and so on and so forth. I might point out that I was the applicant. We didn't make that mistake. And those are just a couple of things just to keep in mind. Again, you're going to find all that stuff in the formal requirements. So it's easy to find. Go there first. The answer is going to be there. It's a very complete guidebook. Let me just talk a little bit about the transition rules. First of all, what if you've already got a case that you've got continuing records in place? As I said, you can either continue with one continuing record if you want to. No reason to separate the records unless you want to, unless the case is getting big or you think it's going to be easier. You can do a 14B and ask for an order to separate the records. And under Rule 9 sub 23, it allows you to have separate records with the first document filed after July 1st. Okay, so that's what happens if you're in a family branch site now. If you're in a non-family branch site now, so you've never had the continuing record system before, Rule 9 sub 22 is what you look at. And as I said, the first person to file a document after July 1st has to start the continuing record unless the court orders otherwise. Now, before you have heart palpitations for those 5 accordion file folder files that are sitting in your drawers, it's not as bad as it sounds, because remember I said when you're starting a continuing record and you've got an RCP case and it's now under the new family law rules and you want to do you have to do a continuing record, it's not so bad. You just have to pull together a part 1, so pleadings. If you're the applicant or a plaintiff or a petitioner, the endorsement section, the financial statements, right? That's what's going to go in your part 1 together with your table of contents. And then your part 2 doesn't have to begin at the beginning. That's the good news. It just has to begin with the step that you're taking in the case. So if that means you're bringing a motion now, then it just has to start from this motion forward. And again, you've got the option to do the applicant's record and respondent's record, or simply do one continuing record for the balance. So that's at your option. We have a transition rule on forms. As you know, you can continue under the rule to use the old forms provided they contain substantially the same information, and that's time limited. You can only do that up to January 1st. I have a mental block on this. January 1st, 05. So our office has just said, listen, we have to convert to the new forms anyway. We might as well just start using them. That's what we've been doing. But you do have that window of opportunity to get organized and start using the new forms, but you don't have to. So you've got until the end of this year to use the old forms. For those of you who haven't had to do anything yet with a continuing record over the last 6 or 7 weeks, your time is coming. Just as I say, remember that you've got those 3 rules and the formal requirements. That's where you're going to find all of the information. It's actually in my office. Maybe they're just humoring me, but everybody seems to think that this is working quite nicely. It's really not that hard, and we're doing, as a matter of course, separate records so that we are controlling our own record, and that seems to be working very nicely. So best of luck. Not that, of course, I think you'll need it. If you have questions, look at the formal requirements and the rules. And I was going to say call me, but I would say call Risa. How's that? Thanks.
Good morning, everyone. My name's Linda Carello, and I'm Consulting Manager for Family Operations with the Ministry of the Attorney General. And I'm going to be speaking about the continuing record. I'll probably repeat a few things that Laurie has already mentioned to you, but I hope I'm also going to be providing some extra detail that will be helpful when you're dealing with staff at the counter. So as we know, a person starting a case must prepare a continuing record, serve it, and file it with the court. That's all set out in Rule 8. And as Laurie mentioned, certain simple cases and cases that compose a significant percentage of our caseload are exempt from the requirement to prepare a continuing record. And these are the joint application for divorce, a divorce application, but if the respondent files an answer, the respondent will prepare the continuing record at that time. A motion to change a final order for child support that is on consent, a motion to change a final order for child support, but if the respondent files an affidavit that sets out any disagreement, then the respondent files or prepares the continuing record at that time. And finally, cases started before July 1, where there's a notice of change in representation or a notice of motion to be removed as a lawyer. In these exempt cases that are listed in Sub-Rule 9.2, Documents should be filed as a package, clipped or otherwise bound together, so that documents can be added to a continuing record if it's needed later. So no Surlocks binding, please. The parties, represented or not, and not court office staff, are responsible for ensuring the continuing record is up to date and that the judge and each party is able to refer quickly to a document being considered at a hearing or conference. You should also know that Subrule 7.6 sets out that the court file number and the description of the parties as applicants and respondents will remain the same on a motion to change an order, a status review application, an enforcement, or an appeal, no matter who starts it. Unless, and there are always exceptions, the enforcement is to enforce a payment order, in which case the parties may be described as payer, recipient, or garnishee. Oops. Or an appeal, and the parties may be described as appellant and respondent. If a case is transferred to another municipality, then it may be given a new court file number. The continuing record is the court's permanent record of the case, and generally Part 1 of the continuing record consists of the following sections: table of contents, endorsements, pleadings, and financial statements. Part 1 will exist in every case, and in simple cases, it's probable that the record will only have a Part 1. Each section, other than the table of contents, must be identified by a section tab showing the name of the section. If there are other documents filed in the case, as Laurie mentioned, they are filed in Part 2, and Part 2 is created only when there is a document to be filed in it. Documents are filed in each section and in Part 2, and will be separated by number tabs. All documents are to be 3-hole punched, and there's no standard record fastener. Some court offices use this type of dangerous-looking fastener. Others use the little brass prongs, and some court offices use soft-covered 3-ring binders. And the reason why we use soft-covered binders is because hard-covered binders don't always fit in lateral file cabinets. We can't pull the door down to lock them at the end of the day. So if you're dealing with a court location that's asking for binders, please provide the soft covers. And because the fasteners were not dictated in the rules, the decision of type of fastener has been determined locally. Documents are filed once in the continuing record to eliminate duplication, and no document is to be removed from the continuing record except by court order. Laurie spoke to you about financial statements, and I'll just add that even though they're not to be filed, remember they're still to be served. The income tax returns are still to be served. If the clerk determines that a part of the continuing record needs to be continued in another volume, then the party filing the next document will be asked to create a new volume. A new volume of Part 1 will consist of the table of contents, pleadings, and financial statements section. Volume numbers should be recorded on the table of contents along with the section and tab number. It may be best to continuing the tab numbering from the previous volume, regardless of whether the volume is added to Part 1 or Part 2. Laurie's told you that in all cases, a continuing record may be separated into applicant and respondent records. And I'd just like to remind you at the Superior Court of Justice and for standard track cases, which are usually divorce and property cases at the family court, a record may be separated into applicant and respondent records by election by a party on filing their first document, by court order, or at a party's request at a case conference, settlement conference, or trial management conference. At the Ontario Court of Justice and for fast-track cases, so that's not divorce or property, at the family court, a record may be separated into separate applicant and respondent records only by court order or at a party's request at a conference. At the Ontario Court of Justice, there's no election for separate records by a party on filing their first document. Rule 9 describes the distinct records. We talked about the motion to change a final order, where a support order is filed with the director of the Family Responsibility Office. The person bringing the case before the court will prepare a support enforcement continuing record. So in most cases, that will be FRO. And as well, at the Ontario Court of Justice and the Family Court, there will be distinct records for child protection cases and status review cases. Rule 9 of the formal requirements provides more information, and as Laurie mentions, this summary of charts, I carry it with me wherever I go, will be invaluable. Now, if you haven't already started, each of you should have the supplies you'll need to create your very own continuing record that you get to take home with you. And we have to apologize to the ILN sites because you were provided only with one fastener. You'll need a second fastener in order to complete this exercise. So, if you'd like to take those supplies and take a bit of time to create your continuing record, I'll give you a hint. Look at the table of contents. That will guide you through it. And this is as close to a test as you'll get today. So we'll take a few minutes, and then we'll see how you've done.
To them about like the cover, and tell them why the cover's the way it is. Like tell them go through. Yeah. I would just describe it. And just, you know what's here, why that's there. Just Oh really? I think we need a musical interlude or something. Jeopardy music. Yeah. It's cute.
Okay, just a few more minutes, and then we'll review the order of the documents. Okay, I hear a little less rustle of paper, so I think we can resume. And I have my own version of the continuing record here, so we'll see how yours matches with mine. And if I could carry a tune, I would have done the Jeopardy music during that interlude, but you wouldn't have wanted to hear it. So, part 1 of the continuing record. The part number is in the upper right-hand corner, just below the court file number. This court file number represents the new kind of case numbers you may be seeing at the, being provided by court offices. And if this had been, if the respondent had filed a blue respondent's record, then this continuing record cover would have been renamed applicant's record. The applicant's name is in the left-hand box. If the applicant were represented, lawyer's information would be in the right. Respondent is below. There's instruction on the front of the continuing record cover to the parties about filing a separate respondent's record. So particularly a respondent who's unrepresented will see that that election is available. So the first document behind the cover should be the cumulative table of contents. The next would be an endorsement section tab. And the rules or formal requirements require that there be at least 3 blank endorsement sheets. Each court office may have its own style of endorsement sheet. You might have a supply in your office, or you might ask the court office what they use, or even the court office might supply the 3 blank sheets. In this case, there had been a notice of motion filed, notice of motion without notice, and an order came as a result of that notice of motion. So the prepared order would come behind the blank endorsement sheets, still in the endorsement section. Next would be the pleadings section tab, and behind it, the first numbered tab, 1, for the application. Jane Feuding has filed her application, and there are claims that require a financial statement, and she's also required to file a summary of cases, and that is behind numbered tab 2. Sorry, a little confused there. The summary of court cases is behind the application at tab 2. Behind tab 3 is the respondent's answer. So behind the pleadings section are the pleading documents, applications, answers, and replies. Next is the financial statement section tab. And because Jane filed her financial statement with her application, her financial statement is first behind tab numbered 1. John Feuding's financial statement was filed with his answer, and it's behind numbered tab 2. That's part 1. As I mentioned, there had been a notice of motion without notice filed. So in this case, part 2 was created for the notice material. There's no endorsement section, there's no table of contents, and behind first tab 1 is the notice of motion. Behind tab 2 is the affidavit general in support of the notice of motion. And for this particular case, for some reason, it went beyond the 200 days without being set for trial, and so a notice of approaching dismissal was prepared by the clerk, and it's been filed behind numbered tab 3. So how do we do? Pretty good? Good. Okay. So we're going to have a question and answer section at 10:30. So if you have any questions about the continuing record, I'll be available to help answer. Thank you.
Good morning, everyone. It's now been an hour since we've been here. Everybody still seems awake. That's a good sign. Rules aren't exactly the most fun topic. And sitting here, and I'm sure over the past 6 weeks since the expanded application of the family law rules, you're thinking of a number of things, but I wouldn't be surprised if one question in your mind is why? Why the family law rules? Why do we need case management? And Risa touched on it a little bit, and I'm going to expand on it a little bit and explain to you a little bit about what case management entails and point out some of the rules that are probably going to be jumping out at you day to day. Now, the concept or the philosophy behind the rules is quite simple, and it was as Risa said. We've recognized that family law is different than other forms of civil litigation because there's emotional turmoil involved. Maybe not turmoil all the time, but there's emotions involved, and that can drive parties in one direction or another. And the family law rules are intended for parties that are going through this type of conflict, and the emphasis is on alternative forms of dispute resolution, trying to narrow the issues for the parties, and trying to take out the conflict that can be compounded by some of the traditional forms of advocacy that we know, i.e. the motion. Some lawyers tend to still like to argue motions, but the focus on family law now is to try to resolve it, avoid the motions. Let's try to get to a resolution that makes sense to everybody involved. So we've got this concept and this philosophy, which is great. But now, do the rules actually have anything in there that can supply us with the tools or the procedures that we need to get there? And the answer to that is yes. And we first look at Rule 2 sub 5, and I'm going to read that rule to you because I just told you what the philosophy and the thinking was behind the family law rules. And if you look at Rule 2 sub 5, it says the court shall promote the primary objective, and Risa mentioned the primary objective, and that is to enable the court to deal with cases justly by active management of cases, which includes, at an early stage, identifying the issues and separating and disposing of those that do not need full investigation and trial, encouraging and facilitating the use of alternatives to the court process, helping the parties to settle all or part of their cases, setting timetables, or otherwise controlling the progress of the case, considering whether the likely benefits of taking a step justify the cost, dealing with many aspects of the case as possible on the same occasion, and if appropriate, dealing with the case without parties and their lawyers needing to come to court on the basis of written documents or by holding a telephone or video conference. Wow, we have some consistency. We've got this philosophy, this background idea of what we need to do, and now we have some direction from the rules that this is how we're going to meet that by case management. And what does that involve? Well, the very first step of that implementation of case management is achieved by early judicial intervention. And the primary tool to achieve that is the case conference. And based on Risa's survey of the people in Toronto this morning, most of you are familiar with the case conference. The case conference at the case conference, the judge is going to canvass the issues, set timelines, and it's wonderful, but we've got consistency again. If you look at Rule 17 sub 4, which talks about the objectives of a case conference, it's amazing. I mean, we've got Rule 2 sub 5, we've got the background philosophy, and now we've got Rule 17 sub 5. The purposes of a settlement conference include exploring the chances of settling the case, settling or narrowing the issues in dispute, ensuring disclosure of relevant evidence, noting admissions, obtaining a view of how the court might decide the case, and it goes on to talk about timelines, etc. So now we've got consistency. So what does this mean? Does this mean that all of a sudden the court and the case management system is actually controlling the way that a case proceeds? Does that mean that the lawyers and the parties themselves don't have control? Not at all. That's not what it means. It is true that the first step in every case is, except in the very unusual circumstance of urgency, it's going to be a case conference. But that doesn't mean that you start your application and within 30 days you're before a judge on a case conference. No. The court realizes that lawyers need to run the case, the parties need to run the case. So you have a timeline, and that's under Rule 41 for all cases in the Superior Court of Justice that are commenced after July 1st, 2004. Your timeline is 200 days from the date that the application is commenced. If nothing has happened in 200 days, in other words, if there hasn't been a case conference, settlement conference, judge, or an order dismissing the thing, you will get a notice from the registrar saying your case is going to be dismissed unless you have a case conference or settlement conference. So it does provide the parties and it provides the lawyers with some control over their case, which is great. So now we know that there's a process in place to help expedite things, to provide an alternative form of dispute resolution. The case conference also avoids the motion. But for those of you that have any experience with the rule about case conferences and motions before the new rules came into force on July 1st are thinking, okay, great, so what we've turned this now into is the case conference before every issue. Well, I'm happy to say, and most lawyers are happy to say, that that's no longer the case. You do not have to have a case conference before every motion. You only need to have one case conference dealing with all the substantive issues, and once that's done, you can proceed with your motions. So you're not going to be in court all the time dealing with case conferences. The court provides controls and a timetable, but it's pretty liberal when you think you've got 200 days before you actually have to put this before a judge. And the reason that you want to do that is quite simple. If the objectives are to try to narrow the issues and try to come up with a way of resolving them, whether it be at the case conference or whether the case conference is just step one, you've got to be in a position where your case is somewhat ready, where you can actually identify the issues and canvass them thoroughly. It doesn't make much sense to commence an application and then have a case conference a week later simply to say, all right, we've dealt with the substantive issues, now we can proceed with motions. It kind of defeats the purpose of the rules, and it's really of no benefit. The way the rules are designed, it allows for that benefit. Great, we've got all this. We know about the 200 days. Starting to sound consistent. One thing you should be aware of, Rule 41 that talks about the 200 days, that only deals with cases started in the Superior Court of Justice after July 1st, 2004. The Ontario Court of Justice is governed under Rule 40. It also has the 200-day deadline. And the Family Court, Superior Court of Justice, which is jurisdictions such as Newmarket, such as Hamilton, and you'll be happy to know that there's a list of which courts are the Family Court of the Superior Court of Justice under Rule 1, Sub 3. Rule 39 governs the case management there. But again, they do have that 200-day deadline. Either you or your principals, actually, your lawyers, should actually take a look at the rules to see which court you're in and what exactly case management entails. But the general premise exists in all three courts. Now, with the establishment of the case conference, the settlement conference, and a trial management conference, and the expanded use of these family rules, what probably concerns all of you most is, well, what does this mean to me? What changed timeline-wise? What do I have to do? What needs to be filed? What needs to be served? What do I have to put, what do I have to put in the tickler system? What do I have to do? But, if the lawyer that I work for says to me, well, we've got to do this, that, or the other, I want to understand where things are coming from. So you already know about the 200-day deadline. Case conferences, settlement conferences, trial management conferences all require briefs. They're different briefs. Case conference brief, settlement conference brief. The forms are provided for in the rules. It's Form 17A through, Form 17A through to 17E are the various forms. Timelines for service and filing. Case conference brief or settlement conference brief, or for that matter, trial management conference brief. If you are the party requesting the case conference, settlement conference, or the trial management conference, or if nobody has requested it, it is the applicant who must serve and file the case conference brief within not later than 7 days before the scheduled hearing of the case conference. The other party, 4 days. So if nobody's requested and it's a matter that's on consent, 7 days applicant, 4 days respondent. If the respondent is the one that actually requested the case conference, 7 days respondent, 4 days applicant. That is Rule 1713.1. Now, for those of you that are coming from a rules of civil procedure jurisdiction, Toronto, Brampton, Toronto probably doesn't apply because we've had case conferences here for a while under the Toronto case management system. The confirmation form. A lot of people are used to, in the regular course, no case conference, you've only got to confirm motions. You've got to confirm case conferences, you've got to confirm settlement conferences, and you have to confirm motions. It's one form, Form 14C. (14C) is a little bit more particular than some forms that you might be used to. There are certain things that you've got to put in there. For example, if a case conference was held, you have to say when it was held and who it was held by, according to the form. Make sure you check off the box. There are certain instances where if a confirmation form hasn't been filled out, whether it be for a case conference or a motion, it won't be heard, it won't be listed. It's very important that you pay particular attention to the form. So ensure that it's filled out correctly. Time for filing motions. Very similar to the rules of civil procedure. A little bit different, but pretty much the same. 4 days, service, notice of motion, and affidavit. Filing used to be 3 days under the RCP. For the motion and the affidavit, it's now 2 days before. So you serve 4 days, file no later than 2 days. But the rule says as soon as possible and not later than. So if you serve it 4 days before, it's probably best to file it as soon as possible. One little difference. The rules of civil procedure talked about when you file your responding materials, any materials in response. Family law rules don't specifically say anything about when you file materials in response. What they do say is that no materials are to be filed later than 2 days before the motion is to be heard at 2 o'clock. What does that mean? Responding materials, not later than 2 days before the hearing of the motion, 2 o'clock. Again, the confirmation form, very important, even more important in the motion. I mentioned whether or not a case conference had been held. There's another part that's really important in the confirmation form. It talks about which pages the judge should read. Because if you've got 9 volumes of a continuing record, the last thing that a judge wants to do on a motion is guess what they have to read. So ask the lawyer you're working for, what do they need to read? Put in the page numbers, put in the tab numbers. Let the judge know exactly what it is that the lawyer you're working for expects the judge to read on this motion. So great, we've got some timelines now. All right, we know the drop dead date, 200 days. We know when we've got to file a settlement conference brief. We know when to file a case conference brief. We know when we have to serve and file a motion record. We know that the confirmation forms are due. And by the way, if I didn't mention it, confirmation forms are due 2 days before the date that the matter is to be heard. No later than 2 o'clock. So we've got that. Great, you're ready to go. You can go on your case conference, motion, or settlement conference. Not exactly. For those that are coming from the rules of civil procedure particularly, this is a bit of a change. Rule 1312 requires an updated financial statement before any motion, case conference, settlement conference. So what that means is you either do a completely new financial statement before the motion, case conference, settlement conference, or you have the client swear an affidavit that says there are no material changes. Now, you don't have to do that in every case. As long as the financial statement's not more than 30 days old, you're good. But if it's more than 30 days, you've got to do it. There's 2 other short points that I just want to touch on. Under the rules of civil procedure, affidavits of documents, they were a given. Not anymore. They have to be requested. Does that mean you're not going to have to do them? No, but under Rule 19, if a party says, I'd like an affidavit of documents, it's going to have to be done. But there's nothing in the rules that requires it, it's just on request. With questioning, no automatic right. Need leave of the court. And the reason for these changes go back to the beginning. What's the underlying philosophy? Let's do something a little bit different. Let's do something that is not as antagonistic as the regular advocacy procedures. Not every case needs an affidavit of documents. Where there's a simple case, you're not going to need it. Not every case is going to require questioning. So they've streamlined it a little bit, and in effect, one of the difficulties that one of the complaints that a lot of lawyers had was they were using questioning or cross-examinations to the umpteen to actually delay matters and to increase costs. Well, that's gone. You can't just do it as of right. In your materials, you're going to find a comparison chart. The comparison chart deals with comparable rules in the rules of civil procedure and in the family law rules. It deals with various things: service, counting time. I think it's at the last tab of the materials, tab 5. Sorry, it's Appendix A. You'll find their comparison charts. So when in doubt, aside from going to the rules, a quick study guide would be to take a look at the chart. Just take a look and see, and if you've got questions, ask the lawyer that you're working with. But this will provide you with a general guideline. Probably the most important thing that you can take out of this is that this is supposed to be simpler, supposed to be easier. And it will be as long as we all get used to it. And that's going to take a little bit of time, but once that happens, it'll be fine. In order for that to happen, though, the cardinal rule that applied, whether it was rules of civil procedure, whether or not it's the family law rules or any other set of rules, applies. Know the rules. Thanks.
Well, hello again. I'm going to talk a little bit about some important bits of information before I go into my topic, which is court resources. I wanted to speak a little bit about the transition provisions in the rules, and in particular, I'm looking at Rule 1, sub-rules 13 and 14. And I would encourage you to read these rules afterward. It's difficult to talk about them, but I'm going to go into the details, but ask you to look at them again after the seminar. So transition provisions, they're not in the materials, but they're in the rules. And these are rules that tell you what to do about cases started before July 1st, 2004. They deal with case management timelines, what George just talked about, and forms. They're not the same as the transition provisions that were in the rules when they first came out in 1999. And regarding the case management timeline provisions, there are different transition rules for cases started in the different courts. So if you have a case that was started under the existing rules in the OCJ or the family court, there's going to be a type of transition rule. For cases started in the Superior Court of Justice, there's going to be another type of transition rule. And then we had this aberration in Toronto and Windsor, where those locations had special case management rules under the rules of civil procedure, so they have special transition rules. So it got complicated bringing the old SCJ cases into the new system. So that's probably a good starting point. There is nothing in the rules that is catapulting old cases into the new system. So there's nothing that's going to take a dormant SCJ case and bring it under the family law rules. There has to be a step in the case to bring it under the rules. Now, there may be some things happening in individual jurisdictions where they're trying to clear out a backload of cases, but there's nothing in the rules that's going to compel a case or wake it up and bring it into the new system. So I'm going to start first with just what I'm going to call regular Superior Court of Justice cases. They're not cases in Toronto, Windsor, so we're talking about the north, around the GTA, Brampton, for example. So these are cases that were started before July 1st, 2004. So if a step in the case is taken on or after July 1st, 2004, the case will be considered to start on the date on which the step was taken. We need to know the start date because George told us about this 200-day timeline. So that means that the case management time will start to run on the day the step is taken, and 200 days from that date, a notice of approaching dismissal will be sent if the case hasn't settled. So, if your case was started on January 1st, 2004, and you schedule a case conference for August 1st, 2004, the case will be deemed to have started on August 1st, 2004 for purposes of case management. If the case is not scheduled for trial by day 200, so in this example that would be February 17th, 2005, the clerk will send a notice of approaching dismissal, and the case could be dismissed if the steps in the rules aren't taken to save it. So now I'm going to move on to Superior Court of Justice, a Toronto case. So it was started before July 1st, 2004, and that meant it was governed by what was then the Toronto Family Case Management Rules. So if a step in that case is taken on or after July 1st, 2004, the timetable established for the case when it was started applies to the case after July 1st. So if you had a timetable under the Toronto Family Case Management Rules, that timetable is preserved after July 1st. But the new rules regarding the steps in the case apply to that case. So from a timing point of view, you're governed by what existed before July 1st. We can't override a timetable or an order that was made regarding timing, but what we are going to say is now that you're after July 1st, all the steps under the family law rules will apply to you. And then I'm going to move to a Superior Court of Justice case that was started in Windsor. Before July 1st, Windsor had its own set of family case management rules. So there's situations a little more complicated. If a step in the case is taken on or after July 1st and a family consent timetable was made by the court before that date, the consent timetable continues after July 1st. So again, we've got something in place before July 1st concerning timing that is preserved after July 1st. But again, the new rules still apply to that case in terms of the steps and the like. But if there was no consent timetable in that case, then the case management order expires on July 1st. This will mean something to the people out there in Windsor. And if a step in the case is taken on or after July 1st, the case is considered started on the date on which the step was taken for purposes of calculating the case management timelines. All of this is in the rules, so please have a look. We do have transition provisions concerning forms. They apply to the Superior Court of Justice non-unified family court sites for cases started before July 1st only. So typical example, you've got a case in the north. It was in the Superior Court of Justice. It was started before July 1st, 2004. A form that was in use under the Rules of Civil Procedure or the Toronto or Essex Family Case Management Rules can continue to be used if it contains substantially the same information as the form required by the new rules. And that transition provision lasts until January 1st, 2005. That rule was put in place so that people wouldn't have to reissue or get documents re-signed. So for example, if you had started a divorce petition before the rules came into force under the Rules of Civil Procedure, we're not going to make you file a new divorce petition. Or if you got a client to swear a financial statement before July 1st and it comes back, July 2nd or something of this nature, we're not going to make you go out and get the person to redo the form just because the rules have come in the middle of things. Now, there was a question that came in from Windsor, and this is the only set of questions I've gotten so far, but there was an indication that they tried to file a statement of defense to a statement of claim. So I take it the statement of claim started before July 1st, but they wanted to respond after July 1st, and apparently the court staff required them to do a demand requisition to file it. I don't even know what that is. I think generally, and I know there'll be questions about this later, if you do have any problems filing, you should be talking to the court manager in that particular location. But just to respond to this, I think that a statement of defense is really substantially the same as an answer, but the difference is that our answer allows the respondent to make a claim. So if in this particular case the respondent was not wanting to make a claim, just wanting to, in effect, to respond to the statement of claim, I think that without seeing the material, and I'm always reluctant to commit myself in these situations, I think that on the face of it, it seems that the statement of defense should be accepted by the court. However, I do suspect that most practitioners would want to start using the new forms. There's no benefit to using the old forms unless I guess you've got stockpiles of them in your office and want to get rid of them. But I would encourage you to start using the new forms. And as I said, it's only in these situations of transition where I think you'd want to just make sure you can file your old form under the new rules until January 1st, 2005. The balance of this question talked about that there's no such document under the rules to file a reply and answer to the counter, or what was it, new rules. There's no such thing as an answer to an answer to an answer to an answer. If our new rules don't have like an answer to a reply, then you can't file that equivalent. The new rules don't have it. Again, this transition rule is if your document has substantially the same information in it as the document under the rules, you can file it. So I'll just leave that for the moment. So on to one other issue that I wanted to mention, and it's in, I don't know what tab it is, maybe Linda you could let me know, but there is something in your materials about filing fees. Just as there is now a single set of rules on July 1st, 2004, there's also a single set of fees for family cases in the Superior Court of Justice and the Family Court of the Superior Court of Justice. So in effect, the Superior Court of Justice has a new fee schedule which is the same as the one in the Family Court of the Superior Court of Justice. So, and there are also some changes to the actual fee amounts, and we've put that material in the binder, and I will tell you where it is when the people behind. Sorry? Just before 2. Thank you very much for that. So have a look at the fee schedule. And generally there are no fees in the Ontario Court of Justice. So we've just tried to bring parity between the two superior courts. No, and we'll answer the, they have not increased, there's no fees in the Ontario Court of Justice. We're just talking about filing fees in the Superior Court of Justice and the Family Court of the Superior Court of Justice. And there were no fees in the Ontario Court of Justice. Right? Copies. I'm sorry? That continues to be the case. There are no fees in the Ontario Court of Justice except for photocopying. All that was changed was the fees between in the superior courts. So the Superior Court of Justice non-family court and the Family Court branch of the Superior Court of Justice now have the same fees. So have a look at them. So now I wanted to talk a little bit about the role of courts, administration, and court staff in the implementation of the family law rules. There have been some allusions to this throughout the seminar so far, but I do want to indicate that court staff, in effect, are gatekeepers at the front end, and that's why we have things like mentioning late documents, for example. You want to look at Subrule 3.7. It indicates that if your documents are not filed within the timelines, there's a positive obligation on the court staff to reject them. We have no discretion to extend the timelines. If you're out, you're out. You have to get an order. So have a look at, we have no discretion at all, and any exceptions have to be made by a judge, you know, by an order, and maybe the parties can consent, but it's an order that's going to require the document to get filed. So just as a practice tip, you have to remember that consent extensions of time are not permitted by Rule 33, which is child protection, not in the Superior Court of Justice non-family court branch, but for those of you who do some of that, there's no consent extension to the timelines under Rule 33, nor are there any under the case management rules, 39, 40, and 41. You have to get an order to extend that time. Then we've got Subrule 5.3, which directs court staff about documents filed in the wrong jurisdiction. So again, we don't have any discretion. This is a new rule for those of you practicing in the Superior Court of Justice. Okay. Then we've got Subrule 13.7, which talks about the notices of assessment that are required to be attached to the material. You heard about that during the discussions about the continuing record. We, the court staff, have no discretion. We have to reject the financial statement if the documents, the correct documents, are not attached. So don't get mad at us. That's what the rules tell us to do. And the whole point of that was to have that minimal level of disclosure that I talked about. We also do some things to move the case along. Sub-rule, or I guess we call this a clause or a paragraph, it's 17(2)a. It says that if no answer is filed, the clerk can schedule a case conference or set a date for an uncontested trial and get the materials together to put them before the judge. So we have an obligation to move the case along. We have to review the documents in support of a divorce case, just like under the Rules of Civil Procedure, before presenting them to a judge. And we do have specific duties in Ontario Court of Justice and family court cases that are on the fast track, that is, cases that don't involve divorce and property. Those cases get a first court date, and we're required to refer parties to information on family law matters and to ensure that the case is ready to go before a judge. So that's only in OCJ and family court fast-track cases. And that's an interesting distinction, because in the Superior Court of Justice, the case management rule is Rule 41. There is no first court date. So when you go to file your application, you will not get a first court date. The case will come before the court when a case conference or a motion is scheduled. And so there is no clerk there telling people about sending them to, no obligation to tell them about information, but we do have information facilities in the court, and I'll talk about that in a minute. So we've already talked about the 200-day timeline and the clerk's role there, where we'll send out a notice if the case isn't scheduled for trial by that date. So regarding our role in terms of providing information, I think one significant change is that court staff are now able to distribute forms in the Superior Court of Justice. I've been doing this business for a long time, and I always thought it was goofy that we could distribute forms in the Ontario Court of Justice and the Family Court, but we didn't, as a matter of course, distribute forms in the Superior Court of Justice. This, of course, is probably more relevant for unrepresented litigants, but I think it's important for you to know and be able to say to an unrepresented party on the other side, don't come to me, you can get the stuff at the court. And I think it's great, because I think that years ago people used to try to photocopy the little munchkin-sized form at the back of the Rules of Civil Procedure and file it, and I thought that was actually quite sad. And to tell people to go to Dye & Durham and buy 800 copies, of an answer or of a defense was kind of silly. So now we have the forms there to distribute to what I'm hoping will be unrepresented litigants, not your offices. Now, court staff, we don't have the authority to help people with their forms. We have a very difficult role sometimes in terms of determining what's legal advice and what's assistance. So we can review a form for terms of, technical completeness. Is it all filled out? Has it been signed properly, etc.? But we can't turn around and say to people, oh, this is what you need to say in terms of, your affidavit or whatever. We just cannot go there. And as counsel for them, I would I change color if I hear that we're moving in that direction. So we have to be very careful there. We do have a lot of information materials for the public, again for unrepresented litigants, hopefully not for the lawyers in your offices, but we have been providing those materials in the Ontario Court of Justice and the Unified Family Court, and we now have them in the Superior Court of Justice. So there are special guides to procedure. There's a whole set of them helping people to start an application, uncontested divorces. We have a cheat sheet for how to put together the continuing record, how to file affidavits of service, and so we've got all that information. So once again, that's something that helps court staff, but it might help you too if you have an unrepresented litigant on the other side of your case. I just recognized somebody I know. I'm so social, these things. So in any event, We also have what we call a Family Law Information Center, or our jargon is the FLIC. And the FLIC is actually, in some locations, maybe, depending on the facilities in the courthouse, maybe an actual area where the court staff can divert a party to get some more information. Because we have practical issues in terms of clogging the counter. You know, if there's lineups, we don't want to be engaging somebody in a fireside chat about how to deal with their case. And we need to keep things moving. So we would like to divert people to the Family Law Information Center, which has information materials there. And in some court locations where space is an issue, it may very well be that the material is just in, and near the court counter. But that's the idea, that we have specialized material for unrepresented litigants. And court staff will do their best to assess the information needs of the public, again, being very wary of the fact that we can't give legal advice. We have a lot of publications. One of our popular ones is What You Should Know About Family Law in Ontario. There's some information for children. There's a guide called Where Do I Stand? There's something about mediation and how you get a legal aid certificate, how you can get a lawyer. So all kinds of practical stuff. There is the video Separate Ways. Some of you may have seen it. It's about an hour and a half. I think in some locations it's just sort of playing all the time as a milieu for family court proceedings. And all our material can be accessed through the Attorney General's website. The address is in the material, but I'll give it to you now, which is www.attorneygeneral.jus.gov.on.ca. Now, one of the key features, I think, of a Family Law Information Center, in addition to wonderful court staff, are advice lawyers from Legal Aid Ontario. So Legal Aid will provide an advice lawyer. That's something different from the duty counsel in the court. Duty counsel takes care of the daily docket and deals with the unrepresented folks on a day-to-day basis. The advice lawyer is there separate and apart from the docket and is there to provide people with summary, information, and if they qualify, may be able to provide them with some summary legal advice about their particular case. So it may be that an unrepresented person can get the court forms from the court staff. Maybe they fill them out either that day or come back, and they might be able to see the advice lawyer in terms of looking at the content of the form. The presence of the advice lawyer will depend on each individual court site. They negotiate with court management in terms of deciding what the hours will be, where they'll sit, what it's going to look like. So I think that's something very positive, and we are working on refining the services offered through the FLIC. And I just wanted to indicate that our family courts of the Superior Court of Justice, the Unified Family Courts, do have services that are not yet available in the Ontario Court of Justice and the Superior Court of Justice. But there are 17 Unified Family Court sites across the province. Right now there are no Unified Family Courts in Toronto or in the north, and some other pockets across the province. But the sites that do have a Unified Family Court are Barrie, Bracebridge, Brockville, Cobourg, Cornwall, Durham, Hamilton, Kingston, Lorne-Yale, Lindsay, London, Napanee, Newmarket, Ottawa, Perth, Peterborough, and St. Catharines. And in those sites, we have court-connected family mediation services. We offer on-site and off-site services. On-site means go down the hall, people, and figure out Christmas access and come back and talk to me. That's what an on-site mediator is doing. The off-site mediation is dealing with issues that take longer to sort out. We also offer through the Unified Family Court locations parent information sessions, which are voluntary. And there's an information and referral coordinator offered through the mediation service who also provides assistance with information and coordinating mediation. So just to end with some little tips from my end. I'm counsel for Court Services Division, and I deal with court staff all the time. And I wanted to say, be prepared when you're filing at the court counter. I know a lot of you might use process service. Some of you may go yourself. Some of you may have students who go. The lawyers may go. But You or your process server will spend less time at the counter if you give the court staff basic information up front. Know the party on behalf of whom you're filing, the type of document, the identities of the moving parties, and what you're scheduling. Expect to spend a little more time at the counter, and that's not just because the rules are new, but under the rules, all documents have to be filed in the record, so the clerk will need to retrieve the court file and supervise the filings in the record, and this takes time. So bring extra materials with you regarding the continuing record. It's probably a good idea for you or your process server to have extra covers and tabs, just in case something unexpected comes up, as it always does. Have reasonable expectations of court staff. We've told them to have reasonable expectations of you, so it's only fair. They can provide general information about the court process. They can't provide legal advice. If you need to learn about how the rules work in your area, take advantage of local initiatives. Again, on this inquiry that came in from Windsor, I know there was a comment about wouldn't it be simpler just to have a seminar to explain how the system works. I think in a lot of areas, court staff are conducting seminars. I don't know how many of you know if there's a local bench bar court services committee, family court committee in your area. It's always a good idea to find out what they're doing and if they are having any kinds of seminars. And certainly if there's nothing going on in the location from which this question came, we can look into seeing if something can get scheduled. And I think that it is important, as I said earlier, to be aware of the services that are offered at the court. The Family Law Information Center might be something helpful to you too when you're dealing with unrepresented people who can often present some different challenges, and that's something that you can direct them to. So I think in terms of the formal part of the seminar, I think that's it for now. And I think we're probably right on time. And we're going to open things up to questions. I don't know if we've received questions in our little question box, but it looks like, at least in Toronto, people are raising their hands. And I don't know, Andrea, are you going to be collecting questions for us to answer? Because it looks like people are hot to trot. Okay, so I would like to just take a minute to look at them. Let's see. Shepherd Court maintains old rules. So I'm assuming this is 47 Shepherd, which is an Ontario Court of Justice. I don't know whose question this is from Toronto, and I will get to the ILN sites as well. Shepherd Court maintains old rules. I can't read. For files opened prior to July 1st, and insists that case conference briefs be filed in the continuing record. Comments? That's incorrect. We better call 47 Shepherd. Okay, that's the answer there. Now, I do want to indicate that although I think we are wonderful, we being myself and Linda, I do think that sometimes there is a transition period, and I don't think court staff are above making mistakes. Sometimes we've heard about them, and we're prepared to respond. I know that doesn't leave comfort for you when you're in the middle of trying to file something, but I do want to encourage you not to come directly to us. I think you try to deal with the matter through the court management at the counter, and if you don't get results, then you can ratchet it up to us. But I would prefer not to be the point person for the entire province of Ontario. Is there such a thing such as an amended application or amended answer? Yes. You can look at Rule, I love this, it's all coming in. You can look at Rule 11. Yeah, well, I don't even have my rules. This means, you see, I've become like rule crazy. Nobody invites me out anymore. I have no friends. I can do this without even looking at the rules, which really frightens me. But yes, Rule 11 talks about amendments, very similar to what you saw in the Rules of Civil Procedure, all that kind of picayune information about how to amend and reserve. It's all very clear, I think, in the rules. Okay, that's number 2. Ooh, I can't read the handwriting here. Superior Court, Toronto. Do motions require factums? And I think the answer, George, is?
Yes.
Yes.
But there's two things that you should...
Maybe just repeat for the ILN site.
Apparently they were told that a factum would not be required unless the judge required it. In Toronto, a summary of argument or factum is still required for a motion. That's number one. And number two is the rules provide that it may be necessary for a summary of argument depending on the facts of any particular motion. So what I would recommend, and it's something I forgot to mention when I was talking about the timelines, is this. Aside from the timelines that are established in the rules, the timelines for bringing motions, serving materials, that can all be stated within an endorsement at a case conference, which means even though the rules say that the moving party's motion materials are to be served 4 days in advance, the endorsement at the case conference might say 15 days in advance. So even though the rules say what is required for timelines, you've got to take a look at the endorsement. The endorsement may also say that summaries of argument or factum are necessary. So always take a look there. But Toronto, short answer, yes. And with complicated motions, more likely than not, factums are going to be necessary.
No. Thank you. Okay, go ahead. Yeah.
Okay. I have a question about the fasteners and why the fasteners cannot be made, a decision made to have fasteners uniform across the province. And it's probably because particularly the judiciary have a preference, and we just haven't found the perfect fastener yet either. This type of fastener that you received in your package, if the continuing record is more than a few centimeters thick, it's very difficult to open, and you don't often, it's difficult to read information in the left margin. So 3-ring binders are very helpful. It's also easier for adding documents, and if you're replacing the table of contents, you just click it open and add it rather than removing all the documents in the continuing record. But they're very expensive, and again, there's the issue of storing them in lateral file cabinets. So it would be nice if we could have fasteners that would be used across the province. We're just not there yet. There's another question about the divorce registry fee and whether the $10 fee is still to be paid on the filing of a claim for divorce. And yes, it's in addition to the fee set out in the fee schedule because it's under federal legislation, under a regulation to the Divorce Act. So the filing fee that you see in the material provided in your binder is what is paid to the province, and the $10 is on top of that, so it's $167 for filing a divorce application. There was an earlier question from Windsor about, I guess, when the original documents should be filed. It was when starting the application, either general, simple, or joint, does the public receive the original, or is it kept in the file and the copy is given to be served? Continuing records is supposed to contain all the original documents, and because we like to have the application served with the court file number on it, it's easier on court staff when the answer is filed. We don't have to go to the index and search the party names to find the file number. Court offices will apply the file number, issue the application. It's probably easier to create the continuing record at that time, so you would be adding your original application and other documents, trot off, serve the continuing record with the application on the respondent, and then all you would have to do afterwards is file your affidavit of service in the separate sleeve that's contained in the court file.
Continuing records.
Another continuing.
Just need a minute to read some of these.
Okay, so I'll just wing it here.
Yeah.
The question is, if doing a motion to change an order and it's the respondent, what color are the records prepared? Do we prepare 2 records? Are we also required to prepare summary of court cases of those? Sorry, just a little trouble with the writing. And, well, let's start in pieces here. A motion to change, and you're the respondent, and if you're choosing to file a respondent's record, then it would have the blue cover. Respondent always has a blue cover. And do you prepare 2 records? I don't think so. I don't know who asked the question, but if you'd like to clarify, that would help. If you're thinking the record for your own use and then the record to be served on the applicant, then yes, you would have to prepare 2. So I hope that answers the question.
Was there a part 2?
Or was it Part 2? You wouldn't need Part 2 unless there were documents to be filed in Part 2. And summary of court cases is usually prepared by the applicant and filed with the application. And yeah, do you include judgment you are changing in endorsement? Okay, so if it's a motion to change, and this is the first time this case has been at that court, the parties have moved, and now you're filing at a new location where the case and the order wouldn't exist at that location, then yes, you would have to attach the order that's being changed to the documents, and it would be part of the motion to change. It wouldn't be added to the endorsement section.
Sure. This question, it's talking about extensions of time under Rule 3 sub 6. And what it's dealing with is, the question is, under Rule 41, it says that Rule 3.6 doesn't apply to requests for extending times under that rule. Rule 41 deals with case management, and Rule 41 specifically speaks of the timelines provided in that rule, which are the 200 days. What it means is you can't extend the time, the 200-day deadline, without an order of the court. The question was, does that mean that if you want an extension of time to file an answer, so that you don't file it within the 30 days, is it all right to serve, if you get the consent of the other side, just a consent to late filing? And that still is okay. It's only in relation to the timelines required specifically under Rule 41 that you cannot extend on consent. I hope that answers the question.
Okay, I've got one. Let me look at that one. In Brampton Superior, if all you want to do is file a notice of change of solicitors executed after July 104, do you need to use a continuing record? No, it's one of the exemptions to having to do a record. Have a look at the transition provisions that Laurie talked about. So it'll be in Rule 9. And can you just file the Superior Court's documents as usual? I think my response would be yes, because if they've already been signed and all, it would fall under the transition provision for forms. But as Linda was just saying, I think the new forms, if you do want to file notice of change, are simpler, I think, probably. But if they're already signed, go for it. No, just to clarify, the question was if they were signed afterward, can you not use them? No. The transition provision in the rule indicates that if the old forms have substantially the same information in them as the new forms, you have basically a rain check to file them up until January 1st, 2005. I'm just saying that the intention behind this was, you had an old form, you got it signed, your client signed it, lives, in France or something, it finally comes back and you're sitting there thinking, uh-oh, the rules have changed midstream. That was why we had a transition provision, but that's not a requirement for filing.
Could I just ask one more question dealing from that? The moment that document is filed, which actually it's a notice of intention to act in person, does that also automatically start the clock ticking for the client? So that right now in the Superior Court, unless they wake up, nothing happens. But if one files now a notice of change of solicitors, notice of intention to act in person, does that automatically mean that she only has 200 days to finalize the matter?
Yeah, it's been difficult to define what a step in a case should be. So we've taken it that it's any document filed or any event scheduled. So a notice to act in person would be a document filed, so that would start the 200 days.
Thank you very much.
Yeah, it wakes the case up.
If I could just add something, I noticed that you said would only have 200 days to finalize the matter. That's not what the case management requires. What it requires is that steps are taken to move the matter forward within the 200-day period. So if no steps are taken from the time the notice of change is filed and 200 days pass, the registrar will then serve a notice giving the party 30 days to either schedule a conference or the matter will be dismissed.
It's 200 days if it's not on the trial list.
Right.
If it's not scheduled for trial, then we're going to wake you up, so to speak. Okay, and go ahead. Because
I
can't
have
read this.
a question about old versions of financial statements and whether they're removed from the continuing record Part 1 when an updated financial statement is filed, and the answer is no. Documents are never removed from the continuing record, and I'll just add that there has been attempts to move documents from the continuing record to the trial record, and no. Documents filed stay in the continuing record, so updated financial statements would just be added to the back of that section. There's another question about Form 13A, the Canada Customs and Revenue Agency direction, and does that get filed in the continuing record? And the answer is yes. It's filed in the continuing record because it supplements the financial statement and would explain why there are no notices of assessment attached, perhaps. And I'll also just add about the financial statement, too. There was a change in Rule 13 about persons under the Indian Act, and you'll see it again, and the declaration on the financial statement can be completed by a person under the Indian Act, acknowledging that they are not required to file income tax returns, and so that's why they're not attached in the notice of assessment.
I have one that I might need your help with. How do you want uncontested divorce materials presented? Because we're saying they don't have to be in a continuing record. So I think we're just saying clip them in some way.
Yeah, something that will allow us to attach the clerk's checklist. The clerk prepares a checklist that indicates to the judge that all the right materials have been filed. And we're also going to need to attach an endorsement sheet that the judge will complete. And so, those, I don't know what they're called, those clippy things, an elastic band, a large paper clip, whatever you can
A
find.
lock of your hair.
Yeah, just something so that they'll be bound together and not confused with other documents that might be in the file.
Okay, do you want to have a look at those? And then it's where to file affidavit updating the financial statement.
That we've determined should be in the financial statement section of the continuing record. It just makes sense that all that financial information should be kept together.
Yeah, and then the other question is where a client has multiple notices of assessment for each year, do we attach them all to the financial statement, I'm assuming? And I think the answer is yes.
Yeah, 3 years.
Why guess?
Yeah.
And then no Surlocks binding? I can't read that.
Right.
Case conference briefs too?
Okay, if you want to Surlocks your case conference briefs, because they're going to be returned at the end of the conference, and Surlocks binding is most convenient, sure. The reason I suggested no Surlocks binding was where we know documents may be added to a continuing record, or there's that potential. The court can always order that a conference brief be added to the continuing record. We don't expect that to happen too often, and when it does, we'll just rip it apart.
Why don't you go for it? And then there's this one, continuous number tabs, 3 volumes. I don't know what that means.
Yeah, the formal requirements aren't, oh, sorry, the question is about the numbering of tabs when we get into multiple volumes. And the formal requirements don't provide information about when tab numbering should begin and start. And again, just because we could get into many volumes in the continuing record, we thought that it might be best if the tab numbering was sequential. And so from volume to volume, the numbering would just continue. But if you're filing documents and you've started volume 5 at tab 1, it shouldn't be rejected. You would just have to be very sure that in the table of contents, you're indicating that it is volume 5 and that we're starting again at tab 1.
Got 2 questions here. The first one is, how do we bring an emergency motion prior to a case conference? Milton says you need leave of the court first. You're absolutely right. You do need leave of the court to bring a motion on an urgent basis. There's 2 ways to do it. The first one, and probably the easiest one, is to do one comprehensive motion record where what you're doing is you're seeking leave to bring the motion on an urgent basis. That's the very first head of relief. You shouldn't have any problems filing the materials as long as you've actually sought that relief right at the top of that's what you're seeking first. What'll happen is you get it scheduled on a regular motions list, and the judge is going to decide, A, whether or not it's urgent, and it is a very tough test to meet, very difficult. It's only in very rare and exceptional circumstances that a motion will be heard prior to a case conference. And if you satisfy the test, the judge can do one of two things. He can either, A, hear the rest of the motion, depending on length, time, and that sort of thing, or B, order that the motion that is to be heard on an urgent basis will be heard the next motion date. Option 2 is to bring 2 separate motions, but it doesn't seem to make a lot of sense because the judge won't have all the materials before him. So your best bet would be to bring 1 motion, ask for leave to be heard on an urgent basis. Remember, when filing your confirmation form, your 14C, there's 2 boxes, one about whether or not a case conference has been held. Second box, if it hasn't been held, it says that the motion is being brought on an urgent basis. The second question is, what steps or forms are used for wanting to examine or cross-examine a party? The old form was a notice of examination. What's the procedure now? Has it changed? Well, there's 2 things. One, you've got to get an order from the court permitting cross-examinations or questioning to take place. And Risa, you might be able to help me with this. I don't recall whether or not we've actually got a notice of questioning, but I know what our office has done is basically revised the notice of examination and called it a notice of questioning.
I didn't think we had one.
I don't think we do have
It's
one.
not in my mental repository of forms,
So
but we're checking.
I don't recall there being one, and I think what our office has done is basically modified the notice of examination, called it a notice of questioning, and used it on the using the new form, the table form, and that's it.
See, I'm absolutely right. There was no special form.
Risa is always absolutely
Yes,
right.
thank you. Yeah. Anything, so we've got some questions in the audience? Yeah.
Yeah, if you don't mind, I have 2 questions actually. One of them is with respect to the new volumes and the continuing record. How do we know now, if there's no page numbering, when to start a new volume?
Yeah, that's been difficult for us too, and the rule has been rewritten that the clerk will determine it,
Okay.
which really isn't very helpful because you're going to show up at the counter not knowing that the clerk is going to ask you to start a new volume. So the suggestion that you have a supply of covers and fasteners will facilitate that. And I mean, we certainly hope the clerks are reasonable and, you know.
Right.
Our own clerks. Yeah,
Our own
of course
clerks,
they will.
yeah, of course.
But
Yeah,
I do want to say that, just to explain a little bit about the family law rules, they are created by the Family Rules Committee, and the composition of the committee is set out in the Courts of Justice Act. And suffice it to say that it's a lot of people, representation from the bench and the bar. There's representation from Court Services Division. I'm the Attorney General's designate, even though he's never met me. And there's a couple of other people from Crown, representing the Crown and Courts Administration. And so we have 4 people. It's a vote. It's a majority vote wins. So on an issue like the maximum size of the record before, you know, it indicated in the rules what it was. It was 100 pages. And so, but it's very interesting, the kinds of issues that get debated. Like Laurie was talking about color palettes. I mean, we do deal with some lofty matters and some unlofty matters. And for some reason, the size of the record, the 100-page thing, just got to people. So as representing courts administration, I was saying, you know, we need something, like, you know, even if it's inches or centimeters, you know, we can all sit there with a little ruler, whatever, but we need to provide people with some direction, and we lost despite our sterling arguments. So sometimes, you know, we, I think, are more akin to, we in courts are very akin in terms of the issues that concern us, and we don't always win. So we're going to have to see how it works, and I think we're going to be monitoring the implementation of these rules, including the continuing record rules, fairly closely to see what the impact is. Yeah.
Sorry, I just had one more. Going back to the consent to late filing, we are still allowed to use that to file documents after the 30-day period, or because we were served yesterday with the motion form 14B to extend the time for filing an answer, although there was already a consent to the late filing.
What happened? The court wouldn't accept the consent?
It was the Brampton court. I guess not. I guess they tried to file the materials, and then the lawyer just went and served us with the 14B, asking for an order extending the time or allowing them to file the materials. So we're not sure if we're still allowed to use the consent to late filing.
confusion is probably with Rule 41, and this is what you point out. Rule 41 says a party may not lengthen times, but what it says is the time set out in this rule, not in these rules. All right, the time for filing your answer is not in Rule 41, it's in Rule 10, which means that under Rule 3 sub 6 that says you can, extend the time by signing a consent, you can still do it that way. But that problem shouldn't be, Risa, unless I'm wrong, that shouldn't be happening.
There is a very remote possibility that maybe they've been mistaken in the Brampton court, but remember there are certain timelines that can be extended on consent, and there are certain timelines that just cannot be extended by the parties. And you just have to check the rules, as do we as in courts. So we'll.
Was that at the Superior Court?
Yeah. Okay. Yeah.
I'm the emergency motion question. We did do what you suggested, and we put our relief as number 1 in order that the court grant us leave to bring this motion. It didn't get any further than the court clerk. She rejected it.
Well, that's no different a situation than if you're bringing a motion, if you're short-serving a motion and you're asking for leave to extend or abridge the time, that's always relief number 1. Again, I'm going to have to defer to Risa, but your motion should not have been refused. That should have been through.
That's what I thought.
That was Milton.
Yes, it was.
Yeah,
And only Milton.
Pardon me?
And only Milton.
Yes.
Yeah, I think there's a Milton
Heard that.
trend. Yeah, we've heard that. And so
Okay.
we will look into that. We heard that before today, and in all, I know I'm trying to make light of things. It's only to keep us buoyant, but we have heard that, and we're
Okay.
looking into it, and I
Oh.
regret that happened.
Thank you very much.
Yeah. Do you want to do that one because it's short?
I don't know whether a factum is required to be filed in the continuing record.
A fact? Do you put your
So-
factums in the continuing record?
I don't think we do.
You don't?
No.
Well, should they go in?
We always file them late, just hand them up to the judge. We don't,
Oh,
I'm just kidding.
yeah.
We follow the rules.
What do you think? What's happening?
I don't think so. It's submissions, it's argument, it's not.
Okay. Sounds good to me.
And
Okay.
we'll just be getting into more volumes more quickly.
Yeah.
And usually they're disposed of. It's just for the one particular motion that you need the factum or the summary of argument, and then you don't reuse it and you don't have to refer to it. So,
Okay, go ahead.
There's also a question about the notice of change in representation, and would it be filed in Part 2? And the answer would be yes.
I think that one would be a good one to look at. Yeah, these are both yours, I think.
Question to that?
We were told that it's not filed in Part 2 at one of the court offices.
What is?
What? So,
Notice of change in representation.
yes, so we thought that was kind of weird since people would like to know who the lawyer on record is, so
Yeah.
we were told, no, it's not filed. So,
Is that in the formal
Sorry.
requirements?
No.
Oh.
It's hit and miss on a lot of these.
Yeah.
And, yeah.
That's what it
Yeah,
is.
Well-
so, thinking that it doesn't truly fall within the definition of a pleading.
It should go into Part 2, but we can, as things come up, we can clarify this for staff, so that's something that we should be clarifying for people.
Yeah.
Thanks. Just give us a sec, because a couple more have come in. Yeah. Oh.
Do you know that one? Should we trade?
Go ahead, go ahead.
Okay, this question is, if you receive a notice of approaching dismissal for an uncontested divorce, but the divorce cannot be set down because we're still waiting on the original marriage certificate, do we simply request a case conference, and do we still need to do a notice of case conference issued and served?
Well, yeah, I think it's unlike, I guess, I wonder why you filed the material before you had all the stuff to begin with.
That would be my reaction.
Just get it all together and then go and ask for an uncontested.
The marriage certificate or other document is usually filed at the top with the application and with the Central Registry of Divorce Proceeding form.
my question is, would they even accept it without the marriage certificate? Because usually they don't. The only thing that they're waiting for, and that's why it takes so long, is the clearance certificate from Ottawa. But that's something that once you request, your motion materials are in. As soon as the court gets it, they issue the divorce judgment. But usually, if you don't have the marriage certificate, our experience is that they reject our materials. It's different if you're filing a petition for divorce and saying it'll be provided later, but if it's an uncontested and all you're moving for is a divorce. So the petition was issued, which is fine.
But now, because so much time has passed, and this original marriage certificate, you got a notice, so I want to set a case conference, but do I have to do that form
Right.
and serve it?
But it's uncontested.
Yeah, we have to.
Sorry, what it was originally a petition for divorce that was issued. The time had passed, so they've got their 200-day warning. That's happened now? 200 days?
Because this marriage certificate with the Registrar General's office, the huge backlog, and the client's put in a request 3 times and is still waiting for the original marriage certificate.
But the
So
200...
we can't set down without the original marriage certificate.
Right, so why would you want to...
Well, no, I want to know about the case conference. So I don't want it to go away, so I want to set a case conference date. But do I have to issue and serve the notice of case
If it was
conference?
issued before July 1st, 2004, and you've not taken any steps after July 1st, 2004, there's nothing pulling that case into the new system, so there should be no 200-day timeline. Have you received a notice from the court?
Yeah.
Which court is this?
Toronto.
You got a 200-day note. Is it under the old rules?
I don't know, it might be even over the 200 days, but we got the notice.
Oh, because you're under the Toronto Family Case Management
right.
So it's under the Toronto Family Case Management Rules that they've issued the notice. Then the answer to your question is yes.
I have to serve the notice of a case conference?
You've got to try, but I'm assuming that this is an uncontested divorce and that you've done everything you've had
That's
to do,
right.
but you don't know where the other party is, and
Yeah.
right.
Yeah. Okay.
Yeah, or a motion maybe extending the time.
Yeah, and that's not a function of the rules, that's a function of the old Toronto Family Case Management Rules. That is not the fault of the family law rule. Do we have any, oh, we do, we have this.
Question about an application and Form 8A, the summary of court cases attached, and should Form 8E, the summary have a separate tab? My opinion is yes, it should. It's a document that the judge may want to flip to, and if it has a separate tab, it's just much easier to locate. And also financial statements, do the notices of assessment go attached to the financial statement or under a separate tab? Here, obviously I'm wavering, the notices of assessment are to be attached to the financial statement, so one might argue that they should all be behind one tab.
Yeah.
So
Yeah, makes sense.
let's go for that.
Yeah,
That's what I would say.
yeah, me too. Okay, I got a difficult one. Why aren't the courts consistent? My process server tried to file an application 3 times in Oshawa and got 3 different answers. Then they did not stamp and give us our copy. Why was this done? Aren't we supposed to get a stamped true copy? So I think to answer the first question, I think that there are a couple of reasons why the courts aren't consistent. I think one of them is that sometimes courts administration may make a mistake. We haven't heard of like a barrage of them, but when they do, we are trying to clarify for people because this is a transition set of rules. And I'm reminded of what happened in '99 when the rules first came in, and in 1985 when the rules of civil procedure came in. I was around then. And we had the same difficulties then. So while I don't really want to make light of it, I do think that we need to give ourselves some time to come up to speed, and I'm aware that that can be an issue for you. But it's also an issue for us if people filing aren't up to speed. But a second reason why there's some inconsistency is judicial scheduling and practices in some locations, and I think sometimes local practice that is difficult for us to penetrate. And without wanting to lay blame, I think the point of this is to make the rules work so that we are doing our best to try to make that happen, and we are constantly speaking to our court staff. They had a very extensive training before the rules came into force. We did a province-wide training and actually went to all the locations. But in terms of other dynamics between the bar and the judiciary, that is something that we don't have, we being courts, don't have direct control over. So if, for example, there's some kind of edict in an area that the continuing record is going to have a purple cover. If it didn't come from us, and our staff are being told that that's what is wanted, then sometimes we have some conflict of interest. So I think that the point of this is to try to identify where there are these disparities and deal with them as they come up, but do make a point of dealing with them. So for something like something in Oshawa, it's very difficult to answer this question now. I don't know what the specifics were. I don't doubt that something may have happened, and I'd like to be able to deal with it directly, because if we educate them there, then they'll know not to do whatever it was again. So I don't know what actually was filed and what the 3 different answers were, but whoever raised this question, who is it? Is it you? We can talk about it after.
Okay, that sounds great, because
Yeah,
I
I'd be
actually
happy
went to Oshawa myself. The process is charging $100 per
No,
visit.
That's not good.
And
So,
I have to charge my client.
you know, I understand. So I'm happy to talk. It sounds like there might be some specifics here,
But
so
they
we'd be
only
happy to
told-
talk to you about it
I've
afterward.
talked to Brampton, I've talked to Oshawa. They only said they got 2 hours training for 1 day.
Oh, that's not true.
That's what they told me. That's 2 different courts.
Okay.
But I think, too, the distinction between Brampton and Oshawa is Oshawa's a family court. Brampton's still split between SCJ and OCJ. That may contribute a bit to it. And I also might mention that at every location, there's a more senior office person, a senior clerk or a group leader, and you can always ask to speak with the court office supervisor as well.
Okay, we'll talk. I think this sounds like this has some history to it, so we'll talk to you about it after, if that's okay, because I think we're getting after 11 o'clock. Is that it for now? Okay, well, I want to thank everybody here and in the ILN sites for coming out and hearing us. And I do want to indicate that we do want to keep monitoring the rules, but it's important for us to monitor them. We need to know specifics. So if you are having any particular problems, we'd like to know about them, and I'm certainly not holding out that they're all something we can do something about. It depends what the origin of the problem is. But I'm hoping that over time things will settle down. Having also said that, though, if there is a trend in terms of not just the way the rules are being implemented, but if there are difficulties with the rules or the rules aren't making sense, we are going to be continuing meeting with the Family Rules Committee in the fall. We meet every month, and we are going to be monitoring implementation. So we are looking to see how the rules will work, and if changes are required, again, if there's consensus, they'll be made. So I think that's it for now. Yeah, thanks very much, everybody.